Rousseau?
Justice Kompepe, members of the court, this is an application for leave to appeal a portion of the judgment of the SCA relating to the detention of Mr. Mahlangu and Mr. Mtsweni subsequent to their second appearance in court. And
Justice Kompepe, I'm sorry to interrupt. Please, can we allow our registrar clerk to call the case?
Yes, please. Thank you.
Good morning. I am the registrar clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of J.E. Mahlangu and another and Minister of Police for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded. Thank you.
may it please the court, A.B. Rousseau, SC, together with Mr. Sarel Meiberg and Mr. Casper Badenhorst for the applicants.
Thank you.
May it please the court. May it please the court, it's Roshan Bidesi together with Mr. Mudliar for the respondent.
Thank you, Mr. Petesi. Mr. Rousseau, you have indicated that you will only enjoy 5 minutes of your protection time. You may now proceed with your oral argument.
As the court pleases. Justice Kompepe and members of the court, as I said, this is an application for leave to appeal a portion of the judgment of the SCA, as well as an application for condemnation for the late bringing of this application, and for an order should the application for leave to appeal and the application for condemnation be granted for the order as set out in our written heads of argument. Justice Kompepe and members of the court, maybe I should start with a very brief summary of the facts. We know that Mr. Mtombeni was the investigating officer. There was a brutal murder of 4 family members, 2 parents and 2 small children, and the 1 child survived the ordeal. Mr. Mtombeni then took a number of statements regarding this terrible crime, and on Sunday, the 29th of May 2005, he arrested Mr. Mahlangu. Thereafter, Mr. Mahlangu was tortured, and he orally confessed that he committed these crimes, and because of the fact that he was succumbed by the torture. On the Monday, a written statement was taken down, the written confession, to so-called legalize this written false confession. And based on that, Mr. Mtsweni was arrested. They appeared in court on the Monday. Mr. Mtombeni took this written false confession, discussed it with the state prosecutor. They decided that they were going to oppose bail. Both Mr. Mtsweni as well as Mr. Mahlangu indicated on the 31st of May, being the first court appearance, that they would that they intend to apply for bail. It was also indicated by the state prosecutor that bail would be opposed. Then this matter was remanded to the 14th of June 2005. And thereafter, there were a number of subsequent remands, after which they were released on the 10th of February 2006. They were released after the real culprits had been brought to justice, and after they released these culprits, 2 of them were sentenced to a life imprisonment. These are basically a very brief summary of the facts. Justice Kompepe and members of the court, we respectfully submit that the clerk judgment is the last word on the approach that should be followed in respect of each and every element of the delict of unlawful arrest and detention, being the actio in iuriarium for non-patrimonial loss. And in the de Klerk judgment, it was, if one reads the de Klerk judgment, as I understand it, it is clear what the thought process should be in respect of each and every element of the delict. There must be an intentional conduct. There must be wrongfulness. And when one deals with wrongfulness, it is clear that all the relevant facts must be taken into consideration, and the question is whether it would be reasonable to impose liability viewed through the lens of public policy as infused by the Constitution. Then there's the element of fault in the form of intentional conduct. We read the judgment to say that the special feature, that type of intentional conduct has a special feature in the sense that knowledge of or awareness of wrongfulness is not necessary. And then there's the question of causality, factual causality and legal causality. And there again, we see that the issue of legal causality also involves, as I understand it, public policy, constitutionally infused public policy, that might give a different result when public policy, for instance, if compared to if public policy is applied to the issue of wrongfulness. And these principles are clearly set out in the Klerk judgment. And if we look at the case of the judgment of the SCA, we respectfully submit that they did not follow these thought processes. They deviated from these thought processes. In the first instance, what the SCA did, that the matter before the SCA was one of unlawful arrest and detention. That was the delict. Not the subsequent inclusion of the false confession in the docket. That was a delict subsequent to the unlawful arrest. And what the SCA then did is that they decided that the real delict is not the unlawful arrest, but the inclusion of the docket or the inclusion of the false confession in the docket. And by doing that, Mr. Mahlangu and Mr. Mchweni lost the special features attached to unlawful arrest and detention. In other words, now they have to prove the delict of the inclusion of the docket, which includes knowledge of wrongfulness.
Mr. Rousseau, your protection time has expired. You may proceed.
As the court pleases. That is the first issue. The second issue is that if one looks at the principles clearly and succinctly set out in the case of the clerk, the case of this court, the judgment of this court, it wasn't followed in the case in the SCA.
Mr. Rousseau, listening to you, the distinct impression I get is that the applicant's complaint is about principles not being applied or being misapplied. You say, talking about the SCA majority, open quote, they didn't follow these thought processes, close quote. Open quote, they deviated from these thought processes. And just now also you are referring to something that was held in de Klerk, which again was not followed. Is it so that your cases concerns the misapplication of settled principles?
That is correct, Justice Mlanga. And that resulted in the wrong outcome.
Now, if that be so, as you are probably aware, our jurisprudence says that our jurisdiction is not engaged if all that an applicant is complaining about is the misapplication of otherwise settled principles of law.
Yes.
So with your earlier response in mind about what the complaint is, and I hope you're not going to change, but of course, anybody can always change their mind. So with that earlier response in mind, what is your comment with regard to what our jurisprudence says about our jurisdiction?
Yes, the jurisdiction is, Justice Mahlangu, as I understand it, that if this involves a principle or a case where a rule of general application is involved, the rule of general application or the rules of general application are set out in the case of the clerk. Now there's a new rule of general application that has lifted its ugly head. And that one is that when one brings an application or when one brings an action in terms of unlawful arrest and detention, that is the dealing. That is the law, that is the rule of general application. Look at what the case is. What is the cause of action? And what
you're basically saying, in a sense, it's not really a misapplication, but the introduction of a new rule altogether.
Yes. What is actually, Justice Mahlangu, it's actually both. Is they ignored this and they introduced a new rule. We see that in the Isaacs matter. In the Isaacs matter, the case...
Excuse me, Mr. Rousseau, before you proceed and go to the Isaacs matter, can you please repeat for me what the new rule that you allege the SCA has introduced is?
The new rule of the SCA says that when there is an application or when there is an action that is based on unlawful arrest and detention.
So if you can just slow down a bit, I'm noting what you say, please. Sorry about that.
As the court please, Justice Chiki, what the SCA says is that when there is an action based on unlawful arrest and detention, and subsequent to that, a delict was committed by the police, then the cause of action is not the unlawful arrest and detention. It is that delict. With all the attributes attached to that delict. In other words, the plaintiff cannot now rely on the special features attached to unlawful arrest and detention. He is now saddled with a heavier burden. He must now prove knowledge of wrongfulness.
Mr. Rousseau, do I understand the argument of the applicant to be that the ACA also introduced a new rule regarding the application for bail and its consequences, or the consequences of not applying for bail?
Justice Strong, the new rule that was introduced there, and that is our submission, is that what the ACA says, as I understand it, is that if one looks at the issue of legal causation, The onus is on the plaintiff to prove the unlawfulness of the harm. Which is diametrically opposed to what the Constitutional Court said, per Justice Strong's judgment writing for the other members. Where the delict, in other words, whether bail should have been granted or bail should not have been granted, is merely a factor to be taken into consideration when legal causation is considered. The SCA now says the plaintiff has to prove he is saddled with an onus to prove and convince the court that he would not have received bail if he had applied for bail. And that is, in my respectful submission, a new rule of general application. And we should not underestimate the consequences of this judgment. If we merely look, and this is the point that I wanted to make regarding the Isaacs matter. The Isaacs matter was, with the greatest of respect, correct. But what happened is that the person read the Isaacs judgment, lawyers and advocates all over the country, they misinterpreted the Isaacs judgment, and that misinterpretation of the Isaacs judgment became an antidote for a sick case. And they got away with it. This judgment has the potential that advocates and attorneys in this country will read the SCA judgment and they will interpret it as saying, well, if you have a case based on unlawful arrest and detention and there's a subsequent delict, I'm sorry, you're not going to rely on the unlawful arrest and detention. You will have to rely on the subsequent delict.
Mr. Rousseau, why would... No, it's not JAFTA. Mr. Rousseau.
Justice Mahlangu.
Justice Matopo.
Your video camera is off, Justice Matopo.
It was on, okay.
Justice Matopo.
Mr. Rousseau, the problem that I have, and I want you to navigate it through, it's your recent submission that the practitioners, when they read the judgment of the SCA, not in so many words, they will be confused. And why would the practitioners only read the judgment of the SCA, but not read the judgment of this court in de Klerk? Because if your argument is that the SCA did not follow de Klerk, then de Klerk is still good law, and de Klerk must be followed, and it means the SCA adds to that extent.
Yes.
So practitioners would not be confused. Okay, let me just finish. This goes back to the very first question that my brother Mahlangu put to you. And your response was, it's the introduction of the new rule that now grounds this court's jurisdiction. But if this court has expressed itself in de Klerk, no new rule is being introduced. The SCA may have said whatever they wanted to say, but if it goes against what this court said in de Klerk, should this court have jurisdiction to entertain this case?
Yes, I respectfully submit it does with respect to Justice Matopo. We must bear in mind that the SCA judgment was granted shortly after the de Klerk matter or the de Klerk judgment had been handed down. The de Klerk matter is referred to in the SCA judgment. It is dealt with in the SCA judgment. And in the minority judgment, it says that the de Klerk matter does not contain a majority reasoning. Therefore, it is not binding. And that is how lawyers will read it. And then they will jump back to the SCA case and say, well, the declared matter didn't bind the SCA, so therefore we have this new rule of general application. And it is not succinctly or clear when one reads the SCA judgment whether it followed the declared judgment or not. That is not that clear. And we must bear in mind that not all lawyers and not all advocates and attorneys, we should never underestimate their ingenuity. That is what's going to happen. And if one reads the SCA judgment, that is the impression that one gets, that this is the new rule. There's nothing contained in the declared matter which clearly states in so many words that cannot be done. So this is and will be seen as a rule of general application. And if that is not corrected with respect to Justice Matopo, then that will be the locus classicus of matters similar to this. That is the one.
Mr. Rousseau, I'm sorry to interrupt you. Can I get some clarity? By instituting the claim, which right the applicants wanted to vindicate?
Their right to freedom, their right not to be arbitrarily deprived of that freedom. That is the fundamental right.
Is that right guaranteed in the Constitution?
It's one of the foundational values. It's contained in more than one section in the Constitution, Justice Jafta.
Now, I understand it's a delictual claim that is regulated by the common law. Does the Constitution have any role in determining the matter, or do we have two separate systems? The common law running parallel to the Constitution without any interface.
No. I understand that if one deals with the common law must be interpreted with the Constitution, or it must be interpreted with the Constitution in mind. And that we see in the elements of wrongfulness, and we see that in the element of legal causation. When one deals with wrongfulness, the question as to whether it is reasonable to impose liability must be seen through the lens of public policy, constitutionally infused public policy. So this is not a direct reliance on the Constitution.
Yes,
and we know that...
No, I understand. I just wanted to clear in my mind whether we have the right to freedom of the person, or freedom not to be deprived, or the right not to be deprived of freedom arbitrarily or without a just cause, that is located in the common law separately from the Constitution.
Yes, that is correct, Justice Jafta.
We do have that.
And the Constitution informs public policy.
Okay. Now, I'm not quite sure. You see, in our law, earlier on, this court refused to recognize a claim for constitutional damages in force, and said the law of delict sufficiently protect the rights affected. Isn't that a similar situation here, that we have a delictual claim pursued in order to vindicate a constitutional right?
Just I wouldn't go that far. I would my submission is based on the recognized principles in respect of each and every delictual element. It's based on public policy. Public policy, obviously, is constitutional infused public policy. And reasonableness, in other words, when one looks at the reasonableness to impose liability, one has to look at public policy and also, obviously, a healthy dose of common sense.
You see, the reason why I'm asking Mr. Mr. Rousseau is the judgment of this court in Zealand, which seems to suggest that even though the claim was a delictual claim, but what was implicated indeed was the constitutional right. And this court in that judgment moved from the premise that because there was deprivation of liberty, where an accused person was kept in detention on authority of court orders, just like here. This court said all that the plaintiff needed to prove was the detention. And therefore, the onus moves to those who detained him to justify his detention. And as I think you and I might agree on this, even the common law on that score is consistent with the constitutional approach. If by its very nature, the act is wrongful, all the plaintiff has to do is to plead that this has happened, and the defendant would say, but that was justified. Now, am I wrong to say here, basically, the issue that we are concerned with is the lawfulness of the detention after the second appearance? The courts below says it was lawful because there were court orders. And the applicants say it was not lawful. Now, I just want to understand, if we look at Zealand, which dealt with a similar situation, does it help us in determining whether or not the detention after the second appearance was lawful? Is it enough to say it was on the basis of a court order and therefore it is lawful? Or should we drill deeper like they did in Zealand?
Justice Jafta, as I understand the case of de Klerk, whether an remand order was lawful or not is merely a factor to be taken into consideration. That is not determinative of the subsequent detention. It doesn't determine legal liability per se or legal causation. It is a factor to be considered, because you can have a lawful remand order but an unlawful detention afterwards, and the other way around. It is merely a factor to be taken into consideration, nothing more than that. Nothing has to be proved whether it was lawful or not lawful. Because the dealing here is the unlawful arrest, and that is the point where one should stand to say, well, the arrest was unlawful. I was deprived of my liberty without just cause. That is the dealing.
Well, I thought there was no dispute insofar as the arrest and the detention up to the second appearance. I thought the only issue that the parties are fighting about is the lawfulness of the detention after the first appearance, or am I wrong?
Just so, Yafta, with the greatest of respect, if the principles of the clerk are applied, then the issue, and that is the thought process, that is the thought process followed in the SCA is different from the thought process in the Constitutional Court in the matter of the clerk. So what is the thought process? The thought process is one, was there intentional conduct? Yes. And we're talking about the unlawful arrest because that is the deal complained of. Was there intentional conduct? Yes. Was that intentional conduct with reference to the consequences? Mindful of all the surrounding circumstances, wrongful, in other words, would it be reasonable to impose liability under these circumstances? The answer is yes, because in the case of unlawful arrest and detention, unreasonableness or wrongfulness is assumed. So that element can be ticked off. The next element is the issue of intention. That element can be ticked off because there was an intentional conduct. The mere fact that they touched him or they took control of his person, that is sufficient. So that element can be ticked off. The issue of damages can be ticked off. Then we get to causality. Causality is the problem. And one has to look at the delict being the unlawful arrest, and one has to stand there and to say, well, this person has been arrested unlawfully. Obviously, certain harm ensued. What was the harm? Well, he was taken to court on the Monday. That is harm. The second step, the matter was remanded to the 14th of June. The harm just carried on.
Mr. Rousseau, maybe I misunderstood my brother Justice Jafta, but I thought the question was more a simple one. I thought he wanted to see if you see the dispute in the manner in which he put to you. He says, there's no issue around the unlawfulness of the detention, the arrest and the detention at the stage at which they took place, that is on the 29th and 30th. Yes. And also there is no dispute about the unlawfulness of the detention beyond, or rather, after the first
appearance.
There's the first appearance. There's the first appearance, and the court postpones without granting bail. Let's leave what the High Court decided. We go to what the Supreme Court of Appeal decided. The Supreme Court of Appeal says your clients are entitled to damages between that first appearance and the second appearance. So my brother says, again, no problem there. And then he says, is it not so that what the parties are fighting about relates to the further stage? Isn't that what the fight before us is about now? Nothing before, no, because that has now been settled. Your clients have even been awarded damages with regard to what happened before. Is it not so that the fight now is about what happened from this later point onwards? Maybe I misunderstood the question.
Yes, Justice Mahlangu, that is the question. Maybe I went too far back. That is indeed so. There's no issue as to the...
Don't go too far back, because my sister presiding will soon say your time is up, so be careful.
That is indeed so. There's no issue, Justice Mahlangu, that is indeed the case. The issue is whether the police should be held liable for the detention subsequent to the second appearance. That
And
is
then my brother wanted to know, why is it that Zealand cannot then apply to this later stage, if I may call it that? Why must it apply, or why must it not apply? I think that was what the question was centering on or around.
Yes, we absolutely agree that Zealand should obviously be applied with respect to Justice Mahlangu, because what happened here, there was a deprivation of liberty without just cause. It was arbitrarily, he was arbitrarily deprived after the second appearance. So in that sense, Zealand does apply.
But what do you say to the court orders? You say that the defendant says that further detention after the second appearance was authorized by judicial orders, and therefore it cannot be regarded as being unlawful. It was lawful. In the context of Zealand, then, what do you say to that?
I say to that remand order was, with respect, not lawful, because a proper remand order is an order where all the facts are placed before the court, and the order is deliberately made based on the correct facts. Once you have a blatant lie upon which a court order is based, it can hardly be said that that remand order is lawful. And what happened here is, we know that Mr. Mtombeni lied throughout. He was the investigating officer throughout this case. He lied.
Sorry, then can I ask you, are you saying that the causal chain was never broken and that the SCA is bringing in a new law of general application? That the intentional conduct of the investigating officer at the outset, that causal chain was never broken?
Never broken, Justice Victor. That is exactly our argument.
So then where's the new point of general application
emanating
from the SCA of judgment?
May I refer, Your Ladyship, just to a paragraph in the Justice Victor, to the matter of the clerk. And that is on page 24. It says, the plaintiff, and now this case deals specifically with the case of unlawful detention and arrest and subsequent conduct. The plaintiff does not need to establish necessarily the unlawfulness of the harm, i.e. that the detention after remand was itself unlawful. The plaintiff need only establish that the harm was not too remote from the unlawful arrest. Unlawfulness does not have to be, the unlawfulness of the harm does not have to be established. Then we look at the case of the SCA. It's opposite. It says you have to establish that. As a matter of fact, you have to prove that. The other thing that I wish to refer the members of the Honourable Court to is what is stated on page 25 of the de Klerk matter. It is these public policy considerations that will serve as a measure of control to ensure that liability is not extended too far. And then it says, the conduct of the police after an unlawful arrest, especially if the police acted unlawfully after the unlawful arrest of the plaintiff, is to be evaluated and considered in determining legal causation. It merely has to be evaluated and taken into account.
Mr. de Klerk. Mr. de Klerk, so are you saying that the conduct of Mr. Mtombeni was sufficiently closely connected to the harm?
Absolutely, Justice Mahlangu. Absolutely, because the one is connected to the other. As a matter of fact, he built a titanium chain of causation, Mr. Mtombeni. He arrested the person.
Just a very small issue. I'm sorry, my sister. When you refer to cases, please don't refer to page numbers. Please refer to paragraph numbers. I had to quickly do a word search based on the first 3 words you said to find which paragraph you were referring to, which was paragraph 63 of the judgment. Please refer to paragraph numbers. Sorry, my sister.
It's paragraph number 29.
29.
Yes.
I picked it up at 63.
Yes.
Mr. Rousseau, have you answered Justice Nklantla's question? If
Yes,
you have, I'd like to
yes.
put it to you.
I haven't yet. Yes, what I'm saying is that there is a sufficiently closely connected causative relationship between Mr. Mtombeni's arrest or his arrest of Mr. Mahlangu. As a result of that, he was detained. As a result of that, he was assaulted. As a result of that, he got the confession, the false confession. As a result of that, he was taken on the Monday to Mr. Mokayani to have it so-called legalized. Then, as a result of that, closely connected still, it took this confession to the state prosecutor. He discussed it with the state prosecutor. As a result of that, they decided to oppose bail. And as a result of the fact that he never, at one point in time, came out with the truth, right up until the very end, him being the investigating officer of this matter throughout. So there is a sufficient close connection between the initial unlawful arrest and the full duration of the detention, and that is our respectful submission.
Mr. Rousseau, I would like to refer you to paragraph 41 of the judgment of the Supreme Court of Appeal. And this is purely my view. It seems to me that what is also before us relates to public policy considerations, as the ACA says in paragraph 41, with reference to constitutional values. And there, the conclusion that's reached, it says, public policy considerations determined with reference to constitutional values and the constitutional order referred to above, limit liability for the continued judicial detention to the stage where it could reasonably be expected of the plaintiffs to have pursued a bail application to finality. Is there any authority that you know of that supports that conclusion? I take it this is the rule that you were referring to earlier, yes, that the ACA had introduced.
I am not aware of any rule of general application that states that, Justice Tom. And this is the problem that we have. And on this basis, we respectfully submit that what this actually says is that Mr. Mtombeni can be excused, and that is the question whether is it public policy that a person who cunningly engineered a prolonged detention can be excused or absolved because of the fact that another person didn't do what he should have done, especially in the case of torture. And we're dealing with torture. And there is also a reference in the ACA judgment as to what the court's approach should be regarding torture. And torture is also one of the elements that is contained in the Constitution.
Now, Mr. Rousseau, sorry to interrupt you. in relation to the facts of this matter, because the SCA says in the first sentence in paragraph 41 that the liability could only have continued to the stage where the plaintiffs could have pursued a bail application to finality. Yes. In your opening address, you stated that the applicants had indicated that they wished to apply for bail. At that stage, the public prosecutor, instructed by Mr. Mtombeni, said that the state would oppose bail. What became of that, where the applicants had indicated that they wished to apply for bail? Is that clear from the record?
It is not that clear from the record, Justice Thorne. It appears that there was a problem with the lawyer, that the relationship between the lawyer and Mr. Mahlangu turned sour, and from there on, we don't know exactly why they did not obtain a further lawyer. He asked his family to get a lawyer, but he never got a lawyer.
Just a follow-up on that. What bothered me about the conclusion in that judgment of the SCA, where they said that if Mr. Mahlangu had applied for bail, he would probably have managed to get it, is the basis for that conclusion, because if one looks at the probabilities, we know that Mr. Mtweni, who actually did not make a confession, applied for bail, and his bail was not successful. So it just bothered me that on the probabilities, the SCA would conclude that, in fact, if Mr. Mahlangu, who we know had made a confession, would probably have managed to get bail.
Yes, on the probabilities, Justice Chiki, there are no probabilities of whatsoever nature that they would have received bail. On the one hand,
and yet the conclusion at the end of paragraph 41 in page 788 is that he would, on the probabilities, have had no difficulty. The magistrate would, on the probabilities, have had no difficulty in concluding that the confession was inadmissible. Accordingly, that no case remained against Mr. Mahlangu and Mr. Mtweni. I don't know where that was coming from, actually.
Yes. That is, in my respectful submission, Justice Chiki, if one looks at the facts that were before the court, there was not any chance that these two people would get bail. Mr. Mtombeni testified in court that they were apprehensive of the safety of Mr. Mahlangu and Mr. Mtweni. And if we look at the Criminal Procedure Act, and just on this basis, I apologize, members of the court. Section 64E of the Criminal Procedure Act reads as follows. The interests of justice do not permit the release from detention of an accused where one or more of the following grounds are established. Where, in exceptional circumstances, there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or security. If one reads Section 8A, in considering whether the ground in subsection 4E has been established, the court may, where applicable, take into account the following factors, namely, whether the nature of the offence or the circumstances under which the offence was committed is likely to induce a sense of shock or outrage in the community where the offence was committed. B, whether the shock or outrage of the community might lead to public disorder if the accused is released. C, whether the safety of the accused might be jeopardized by his or her release.
Mr. Rousseau, my difficulty on this conclusion or principle by the SCA is at a level of principle. I am not aware of the legal foundation of this kind of principle in the context that we discussed. The police arrests me and detain me unlawfully. Now I'm expected to apply for bail. Would that application for bail change the unlawfulness of the detention? It seems to me they are introducing the principle of cutting down your losses, which applies in civil matters, and introduced in this kind of matter where your freedom has been taken away, your liberty has been taken away, and now the onus is placed on you to get bail instead of them, as the law tells us, as reflected in Zealand and other decisions, that it is them who should show justification of taking away my freedom. So I really don't understand that principle. I looked at it, I was confused. I couldn't, perhaps you could tell if I'm mistaken in my approach.
Justice Jofsa, with respect, I couldn't have put it better. And that is when I read this, and my learned colleagues, Mr. Meiberg and Barnos, we discussed this at length. We couldn't figure out where this exactly fits in, because this is a novel approach, which does not coincide with one's sense of reasonableness, fairness, justice.
Thank you.
Mr. Rousseau, ought the failure to apply for bail ever make a difference in the determination of legal causation?
Justice Kampepe, we respectfully submit that no, it should not make a difference.
Why?
Because one has to look at the conduct of the person who committed the dealing and the subsequent harm. There could be a situation, theoretically, where a person could have applied for bail. Let's say, for instance, that the person has a proper video footage that how he was arrested, how he was treated, and how the confession was beaten out of him, and he failed to present that at his bail application. In other words, where had he done that, the judge would clearly have seen, but this was an unlawfully obtained confession, I'm going to grant you bail. So there are certainly the possibility of that being taken into account. But as I understand Justice Tron's judgment writing for the members, that it should merely be a factor that should be taken into consideration in determining legal causality, a factor. But that doesn't take away, that doesn't neutralize the conduct of Mr. Mtombeni in this case.
Yes.
It doesn't, yes.
Mr. Rousseau, is this case distinguishable from the SA judgment of Waji? And if so,
Yes.
how?
Yes. In the Waji judgment, Justice Mhlanta, the delict there was not an unlawful arrest. In Waji, the person was lawfully arrested. The delict there was the lie. In this particular case, and in the case of the clerk, the delict that was committed is the unlawful arrest. That's the delict. So in order to determine legal causation, it depends where one should stand. Either you should stand at the position where the unlawful arrest occurred, which is the correct position in my respectful submission, or where the delict was the inclusion of false information in a docket, then that is the delict. And that is the place where one should stand. And that is the vantage point from which one should determine legal liability. In this particular case, it is the unlawful arrest and nothing subsequent to that.
Mr. Rousseau, if one looks at the conduct of the police officer in Waji and the conduct of the police officer in this case, are there no similarities?
There are indeed similarities, Justice Matopo.
So if there are similarities, you would draw inspiration from the reasoning in Waji in support of your case.
Yes, Justice Matopo, that is indeed so. And also, as far as the issue of bail, there is the case, how should an application or a failure to apply for bail, how should that be taken into consideration, and what should the thought process be? Is the matter, and I don't know whether I pronounce it correctly, it's the matter of Carmichael or Carmichael, I don't know how to pronounce that name, Justice Matopo. But there's an indication of how one should treat it. One shouldn't look at the magistrate who was actually presiding and the state prosecutor who was actually prosecuting. One should look at the reasonable magistrate and the reasonable prosecutor.
Mr. Rousseau, can we try and bring the facts in Waji and the facts in, there's an earlier decision of the SCA in Chokwana. You must be aware of that case and this case. A reading of those two cases and this case would indicate that there is a common thread on the part of the police officers to do something that would lead to the continued arrest and subsequent detention of the accused or the plaintiffs. In this case, say for the unlawfully or illegally obtained confession, there was absolutely no evidence against the two plaintiffs before the magistrate. And in the record, when Mtombeni was asked, he alluded to the fact that the charges that they were facing would attract a life sentence. And if one looks at the prospects of applying for bail, particularly the section that you quoted us, I think it's section 60, subsection 4 or E, for them to be admitted to bail, first they had to establish exceptional circumstances, right? In other words, to surmount that hurdle, it would have been difficult because of that confession which was illegally obtained and that confession which illegally implicated Mthweni. So the odds against them. There were odds against them from the beginning. Whether any bail would have eventuated into a success, it's a drop in the ocean.
Yes, Justice Motoko, I cannot agree more with what Justice Motoko has just said. And also bearing in mind that if a bail application was brought, they would not have the benefit of all the other statements because of what is stated in the Criminal Procedure Act. They would only have the confession, and then further, it's a scheduled sex offence, as Justice Motoko has just pointed out. Plus, there is this section that I've just referred to regarding the public outcry and the public disturbance. So the odds were overwhelmingly against that for a bail application. And what I forgot to mention, Justice Motoko, yes, and on that score, I just wish to refer the members of the Honourable Court to a Court Bundle Volume 5 of 8, page 532. This was an affidavit made by Mr. Tombeni, presumably, it looks like it, in an effort to oppose a bail application of Mr. Mtsweni. And that was done late during that year. And what they said here is, I oppose bail. This is now Tombeni speaking. I oppose bail because this is a serious case. That's paragraph 4 on that page. He has been implicated by accused number 1 Johannes Eugene Mahlangu, and he may be implicated by DNA, which is still outstanding. Therefore, believe that he will not stand for his trial as he does not own any fixed properties. He stays with his parents. He is unemployed, unmarried. The community, and that is the important part, the community were already looking for him. And the community has also written a petition which was handed to the Department of Justice that he must not get bail, as his case also involved the killing of women and children. He has got no previous convictions. So the odds were simply enormous against a successful bail application.
Mr. Rousseau, is the date of this affidavit, I can't see it clearly, is it the 8th of December or what? Just
yes, Justice Motoko, it looks like the 8th of December 2005, Justice Motoko.
And that would mean a period of about 6 to 7 months after the initial arrest.
Yes.
So if one looks at the affidavit of Mtsweni, vis-a-vis the fact that he extracted this confession from them, and in the paragraph that you've quoted to us, it is as a result of this confession, correct me if I'm wrong, that now the Mahlangu and Mtsweni are cast in a bad light in the community they live in.
Yes, that is
so
correct.
In other words, whatever prospects that they would have bail have been diminished. Yes. But one does not have to start there. One has to look right at the beginning, yes, when this confession was extracted from them. This is one continuation of, if one were to call it, malafides on the part of Tombeni.
As a
so there could not have been any break.
Justice Motoko. No. And what they did here is that Justice Strong.
Yes, thank you, Mr. Rousseau. If I could follow on from the questions of my brother, Justice Motoko, and refer you to volume 7, please. Page 689. You can also keep in front of you the affidavit of Mr. Mtombeni at page 532. And as I understand the situation, and you can correct me if I'm wrong, this was the affidavit that Mr. Mtombeni had prepared when Mr. Mtsweni had applied for bail. Is that correct?
Yes,
The affidavit at page 532.
532, yeah.
Is that the affidavit that Mr. Mtombeni had prepared when Mr. Mtsweni had applied for bail and to oppose Mr. Mtsweni's bail application?
That is correct, Justice Todd.
And as was noted by Justice Matopo, it is dated the 8th of December 2005. Now, I would like you to take you to page 689 of volume 7. That is the cross-examination of Mr. Mtombeni. Line 5 was put to him. He says, now in June, you knew at that stage, I mean, you have the affidavit of the first plaintiff. You knew that that the facts contained in the affidavit of the first plaintiff simply did not tally with what was found in the murder scene. Plus, you had the fingerprints of Van Rooyen during June. Mr. Makobelo was arrested also during June with positive identification of fingerprints. Now, in June 2005, Mr. Mtombeni had that evidence. And in December 2005, in opposing bail, he did not disclose that evidence to the court. What are we to make of that?
Well, that is just a fortification of his lies. It just corroborates what was expected of Mr. Mtombeni throughout. He started with a lie, and he had to process that lie throughout. Even during the trial, Justice Strong. Even during the trial in the court of first instance, he persisted with his lies, even up to that date.
So what we have in the affidavit of Mr. Mtombeni in December 2005 was a deliberate decision to conceal evidence from the court.
That is correct, Justice Strong.
Thank you, Mr. Rousseau.
I can just maybe add, Justice Kampepe and members of the court, that the SCA decision regarding the mechanical approach, as it is called in our heads, will basically be used in the same manner as the Isaac's decision was used for a certain period of time.
Mr. Rousseau, do you have any further submissions to make?
Yes, Justice Kampepe, the application for leave is dealt with in our written heads, as well as the application for condemnation. We persist with that. There's nothing else that we want to add to that. So, sorry
Yes.
for that. That is
Just on the remedy,
Yeah.
The dissent, Justice Van der Merwe's dissent has actually, let me just get to it. I'm now going to the damages, the issue of damages. I'd like you to address us on that. If we're with you, what damages would be appropriate? I'm looking at page 802, and I see that Justice Van der Merwe thought that if he would have granted an amount of 490 to the first applicant and 450 to the second applicant.
Yes, Justice Chiki.
Do you align yourself with that, or do you differ, and what
Yes,
should we think of that?
Yes, we align ourselves with that, Justice Chiki, and it doesn't seem as if the respondent is seriously disputing the correctness of that amount. So there's not a real issue regarding the correctness of that amount or those amounts.
I just wanted to confirm that.
As the court pleases.
Just before you end your argument, Mr. Rousseau, a small housekeeping matter. I think it's from the top of page 32 of your written submissions, you quote, you repeat a quote, and the repetition takes about 2/3, an entire 2/3 of a page. And what's odd about this is that it's a repetition of a quotation you had made earlier. And you do this, I think I counted about 2 more times where you repeat quotations that you've already made before. This reminds me of retired Deputy Chief Justice Moseneke, who used to say, reading is a very scarce resource for judges, and that we should only be made to read what is necessary to read. Yes. Now you quote and re-quote, and sometimes quite copiously, and please avoid that in future.
As you please, Justice Mahlangu, I apologize.
Thank you, Mr. Rousseau.
As the court pleases.
Just can see what's happening here.
Mr. Petesi.
I'm just waiting for a photo, please, Justice Kampepe. Not coming. The host has removed my picture from the screen. If the host could please just include it and I'll proceed. Or may I proceed just like that? It doesn't matter.
Mr. Bedesi, could you turn your video camera on, please?
I am turning it on, but it says it cannot start because the host has stopped it. The host has now asked me to start my video.
Yes, you may proceed. Now we can see.
I'm now on the screen. Thank you. Technology beats me most of the time. I apologize for that.
You're not the only one.
Justice Kampepe and fellow members of the court, we are obliged as we do to support the decision of the Supreme Court of Appeal. We support it in all aspects, and I will no doubt be questioned on the various aspects contained in the judgment, which was, of course, dealt with Mr. Rousseau. We do not support the decisions of the minority court, and we assume from the reading of the applicants as heads of argument that what they sought to do was to rely on these minority judgments. For purposes of clarity, may I just deal with those 2 judgments? The first judgment was the judgment by Justice van der Merwe, who said in a précis, to summarize it, that if Lieutenant Mtombeni told the prosecutor the truth, there would have been no further detention. Therefore, that was the factual cause of the detention. Now, that is quite true up to the stage of the first appearance. And there's no dispute on that. As Justice Madlanga indicated, we have absolutely no dispute on the facts. We got no dispute from the respondent side on what the judgment of the clerk says. Our only dispute in this matter pertains to the majority judgment, it appears, and of course the meanings of the minority judgments. Justice van der Merwe further goes on, and this is where we have the problem. And he says that he finds that that fact, the failure to advise the prosecutor about the impermissible confession, is also the legal cause, because Lieutenant Mtombeni subjectively foresaw that the confession would lead to post-appearance detention. Now, we have no problem with that approach up to the date of the second appearance, that is the 14th of June 2005, because that is in fact what happened. But this reasoning, with all due respect, ignores the fact that in the absence of a bail application, and especially the fact that no one prevented the applicants from applying for bail, Mtombeni's foreseeability is of absolutely no consequence. It would become of consequence only if it eventuates by positive conduct on his part, and that never occurred. That is on that basis, we do not support the findings of Justice Van der Merwe. Pertaining to the findings of Deputy President Petse, he firstly finds that the 13 subsequent court orders were not the result of a deliberative court process. But no reason or basis is given for that statement. And on that basis, he says, and therefore those 13 further court orders cannot constitute and should not constitute a novus actus. We disagree with that, with respect, because the record will show that there were witnesses. And in fact, the very first one, there was a deliberative process pertaining to the postponement. And that is specifically recorded in the record. We see that the bail, the right to apply for bail was clearly explained to the applicants, and that the matter was postponed in order to enable them to apply for bail. And if we look further at volume 5, pages 465 and pages 506 to 511 and 514 to 517, we will see all the notes of the magistrate throughout. At every appearance, he dealt with issues. There is also a record of where he dealt with bail applications, but it is, of course, not legible in a manner that we could rely on. But it clearly indicates a deliberative judicial process. So on that score, our submission with respect is that Deputy President Petse was incorrect. The other basis, if I may just take a sip of water, please. On the other aspect relied upon by Deputy President Petse, is that the majority ignores the section 12.1 rights that is not to be detained arbitrarily and without just cause. And therefore, so he says, the principle in Zealand must apply. But the principle in Zealand, with all due respect, was simply pertaining to the place of detention and not the fact of the detention. And on that basis, it was permissible to apply or implement a reliance on section 12.1 of the Constitution. This reasoning of Deputy President Petse also is lacking in that. The second applicant, in fact, applied for bail, like it was indicated earlier. He applied for bail and he was not granted bail, although that is merely on the evidence of Mr. Mahlangu, the first applicant. We don't really know, and there's absolutely no evidence to indicate the contrary. Like I said, there are notes, but the notes are assignable. If I may, just for the purposes of completeness, refer the court to page where it appears that some bail was granted. But obviously, like I also say, it's not too clear what is written on that page. It's at page 516. And that was also late, quite late. And it's actually, now that it is mentioned and it strikes me for the first time, it is on the very same date on which that application for bail affidavit was signed, the 8th of December 2005. on that very same day, if we look at that writing, and for some reason that has not been transcribed, although other parts of it was transcribed, it looks like there was in fact bail granted, but we don't know. And if I say that it is that we could rely on it, I would be doing that tongue in cheek. I'm not sure, but it appears right at the bottom there. Knowing magistrates from the criminal work I did, it looks like beskuldig de 2 8 laat 10.000 rand borg op voorwaardes. That's what it appears to be, but I'm not giving evidence, so of course that is up to the court to decide. Also, Deputy President Petse ignores the fact, when he relies on Section 12 of the Constitution, 12.1a, he ignores the fact that that is not the only right in the Constitution. The Constitution gives us various rights. And there is also the right to apply for bail. And there is also the right to challenge your detention as being unreasonable. Those rights cannot merely be ignored, because it is also a right in the Constitution. And those rights are, I submit with respect, put there for a purpose, to protect an accused person who is unfairly or unjustly arrested or detained for whatever purpose, or howsoever detained or arrested. And it is therefore incumbent on a person in seeking to exercise one right, and where one right is infringed and another right is afforded, to use that right to counter the other right. Or else to do that will with respect, render the other right a nullity. I don't have to apply for bail. I don't have to do anything. Unfortunately, this is what our Constitution says. And even more unfortunate for an accused, the fact that Section 60 Criminal Procedure Act provides that in that, and where it's a Schedule 5 or Schedule 6 offense, that the onus to establish exceptional circumstances is on the accused. That would be the applicants in this case. And therefore the applicants were obliged to exercise that right, which is the reasoning I understand the majority of the Supreme Court of Appeal was coming from when they said what they said in their majority judgment. Also, what is more important is that in circumstances like this, the police cannot grant bail, the magistrate cannot grant bail, the prosecutor can't grant bail in the absence of an application for bail. So everybody's hands are tied, and the police's duty to detain comes to an end once he brings the person to court. That is why the majority relied on the fact that had there been a bail application, like in all the other cases, Warji, Zealand, Ibrahim, all the other cases referred to by my learned friend, there were bail applications. I beg your pardon, not in Ibrahim, but in Kyokwana, in Warji, and in Zealand, there were applications for bail. And it is in those applications where the police perpetuated their lie, and therefore they were the direct cause of that further detention. Otherwise, their right to detain came to an end, and their legal liability cannot exceed further than that unless they played some part in perpetuating that detention.
Mr. Bedesi,
Yes.
your protection time has expired.
Mr.
Mr.
Bedesi,
Bedesi?
Yes. Justice Chiki, you are on the screen, that is why I ask you.
Mr. Bedesi?
You've said that in cases like this, there would have been no bail unless the applicants had applied for bail. Did I hear you correct?
Yes.
Okay. My problem is exactly there. This kind of cases like this, because of the false confession by Mr. Mtombeni. And this is the false confession that was engineered by Mr. Mtombeni that made this case like this. And it is on the basis of that false confession that on the first appearance, the prosecutor said that he would like to oppose bail. And it is on the basis of that false confession and the arrest based on, that is the wrongful arrest based on that false confession, that the further detentions then eventuated.
Justice Chiki, with the greatest of respect, on the facts of this matter, we don't know what caused the further detention. It is speculation to say with respect that it was the confession. We would have known that it is the confession if a bail application was brought and Lieutenant Mtombeni persisted.
Sorry to interrupt you. We know though that the real culprits were arrested, and we also know that the charges were withdrawn. And it is now common cause that that confession was engineered as a result of torture. So how can we not know? Yes, how can we not know that in fact it was as a result of the wrongful arrest based on the engineered false confession that led to this whole chain of events?
With respect, Justice Chiki, what our argument is that the unlawful arrest resulted in the detention, which was also unlawful, to the stage of his appearing in court for the very first time. Thereafter, his further detention after the first appearance was as a result of the confession. There is no doubt about that. But that the confession had an effect was only until the 14th of June, when they said they would bring an application for bail. Once they do not bring an application for bail, then we don't know what, in the absence of evidence placed before the court, as to what the cause of the further detention was.
Isn't that a problem for the respondent, Mr. Badesi? Your very answer. If you submit to us, Mr. Badesi, we don't know what caused the further detention. Isn't that problematic for the respondent? And can I point you please to Zealand, which was mentioned by Justice Jafta. Paragraph 24 of Zealand says, it was sufficient for the applicant simply to plead that he was unlawfully detained. The respondents then bore the burden to justify the deprivation of liberty, whatever form it may have taken. Isn't the duty on the respondents to justify the further deprivation of liberty, to justify the further detention? Mustn't the respondents prove to this court, this was the reason, this was the lawful reason for the further detention?
Justice Theron, as I started off, I indicated that I'm compelled to rely, for the purposes of this hearing, on the decision of Supreme Court of Appeal. Is what we rely on, is what we are here to support. And the reason why the onus was not placed on the respondent was because of the finding of the SCA that after the arrest, there was a totally new delict committed. And after sorting the pleadings out for the applicants, the SCA found that on the basis of that new delict, which was no longer unlawful arrest and detention, it was now this delict that had the further repercussions, the onus rested upon the applicants.
And
Oh,
For that reason, throughout the judgment,
Mr. Petesi, I think the question remains that is this not contrary to the accepted position in these type of cases, that once the applicants have shown that they were detained, the onus shifts to the defendant to show that this detention was in fact justified and therefore lawful. That is the question.
Justice Kampepe, that would apply. Oh, I beg your pardon. That would apply in the normal situation where there is no intervening delict. But in this situation, we intervening delict. The plaintiff in the case is telling us, as a result of your having extracted this confession from us, we were detained. So it's simply that prove what you allege, how the SCA approached it, as I understand it.
Mr. Badesi, in your opening statement, you took issue with the third judgment of the SCA, the judgment by Deputy President Petse, to the effect that there was not a deliberate court processes that followed. And you referred us in part to page 506 in volume 4.
Yeah.
Do we know what happened?
Is it volume 5?
Volume, page 506, volume 5, I'm sorry.
Yes.
Can we say from what is before us that there was or there was not deliberate court processes that were followed? Was a discretion exercised in respect of the continued detention of the applicants? If we look at page 506, what happened in court on that particular day, just as an example? Was it a routine remandment? Was there a deliberate exercise by the judicial official to extend the detention, and on what basis?
We cannot ascertain from these records. My only submission is that
who bears the onus to prove what happened? If we cannot ascertain from the record, where must that fault be placed? And who must bear the consequences of that failure?
In these circumstances, the applicant bore that onus because they relied on the delict emanating from the unlawful confession. And once they relied on the confession as the cause of the delict, on the actio injuriarum, then obliged to have established it.
The applicants relied on the unlawful arrest. Once their arrest is proved to be unlawful and it is accepted by the party that it is unlawful, the principle in Zealand kicks in. The respondent must show that the subsequent deprivation of liberty was justified. If the respondent cannot show that, surely that's a difficulty for the respondent. If the respondent cannot show us on what basis, for example, on the 21st of June, 2005, their detention was extended, that is a difficulty, in my view, for the respondent.
I will accept that, Justice Theron, if we do not follow the reasoning of the Supreme Court of Appeal, that the onus was on the applicants to have established this.
We're following Zealand, Mr. Badesi.
On Zealand, of course, that is what Zealand says. But my distinction with Zealand is, Zealand did not deal with detention as such. Zealand dealt with the place of detention. That he had to be detained was accepted.
Deprivation of liberty.
Yes, the deprivation of liberty per se. Once they proved that their liberty was deprived, I just forget the word. I'm sorry, but arbitrarily. That is what they established there. It was arbitrarily deprived. And on that basis, it was just the place that was concerned. That they were supposed to have been detained was an accepted fact. It was just where supposed to be detained. So a bail application or any other evidence was not relevant in Zealand. There was no need for any other evidence. To have asked for any other evidence would have been unreasonable in the circumstances because there's
Mr.
nothing else
Bedesi,
they could have.
Mr. Bedesi, sorry to interrupt you. Sorry to interrupt you. Mr. Bedesi, Mtombeni procured the confession from Mr. Mahlangu. And that confession later turned to have been false. And when we consider the facts of this case, in particular, his evidence at the trial, where he says in June, about 2 weeks after the incident, 12 days thereafter, says there was a positive identification of fingerprints linking Van Rooyen, and in the same month, right, Makubele was arrested. Now, you look at the conduct of a police officer who owes society, the citizen, the court, a duty to disclose proper facts before the court. He's got those two aspects. He says nothing about it, but he places the evidence, or rather the first hearing, he places the docket together with the entire contents to the IO, not to the IO rather, to the prosecutor to say, bail has been opposed. 12 days later, he picks up the statements, nonchalantly sits back. Look at that conduct. December the same year, 7 months later, opposes or deposes to an affidavit opposing bail. Just look at the conduct of that police officer vis-a-vis the rights of the plaintiffs or the applicants, their rights to freedom and liberty. What is your response?
Justice Matopo, my response to that is the conduct of Lieutenant Mtombeni must be seen in the entire evidence. He said during his evidence that it was not the confession as the basis for the arrest and the detention. It was also my suspicion, which, yes, subsequently turned out to be untrue or not permissible, unproven, or whatever. Because he believed, and he said it in his evidence, even to this day, when he gave evidence in the trial court, he said, I still believe that it wasn't only those 2 or 3 who were convicted. There were others because, and he explains, the size of the lady that was murdered and the number of people that were murdered. And at that, this was his belief. It's subsequently found that it was not reasonable. At that age, this is the belief he's working under. And we can only accept his belief at that stage was his belief. And he acted on it. That is my Justice Mato.
Mr. Bedesi, I just want to refer you to the amended particulars of claim, because you made a submission that this matter is different from Zealand, because you said that the applicants have pegged their case on the confession or on the further detention, and I recalled that in fact they pegged their case on the unlawful arrest. if you go to page 21.7.2, you will see there that they are actually saying resulting from the aforesaid arrest, they were then incarcerated for a period of 9 months, and then they then deal with the arrest as well in paragraph 8. So I thought, let me refresh your memory to say that, in fact, they relied on the unlawful arrest.
Thank you, Justice Chiki. I'm well refreshed now that you refer me to that. It is true that they relied on the arrest. But then I come back to my initial argument, Justice Chiki, that the police's right to detain ended once the accused were brought to court. That is, the two applicants were brought to court. Their right to detain ended. And we cannot now ignore the rights of the prosecutor and the magistrate. Because to do so, then it will, in our submission, open the floodgates, in that every unlawful arrest, and there are millions of these all the time, it would prevent arrest from policemen for fear of attracting liability indeterminately. And then also there's no duty on anyone to apply for bail if they're unlawfully arrested. They may just sit there, and by that time, until they are released, and the state will be liable for it. On that basis.
I'm sorry, Mr. Perez. I don't understand the submission. You mean that the police should not be held accountable for unlawfully arresting people? Because you start by submitting that it will open floodgates if police arrest people unlawfully, and now they are held liable for detention after appearance in court. I don't understand that submission.
Justice Jafta, what I'm saying, and I base that submission on the rights and obligations of the other organs of state, the prosecutor and the magistrate. Once there's a deliberative process, these organs are supposed to decide now, should the detention continue, proceed? The police has got no say there. If the police, by their say, perpetuates this detention unlawfully, then of course the police must be liable.
But why should the police arrest people unlawfully in the first place? Because
just
the whole thing starts from an unlawful arrest. Why should we countenance unlawful arrest of people?
Justice Jafta, I'm not saying countenance unlawful arrest. What happens is policemen not trained in the law, and we must accept this, arrest on the basis of a reasonable suspicion.
No, but
at
Mr.
the
Perez,
end of the day...
I'm sorry, Mr. Perez. This argument really troubles me. You and I know that Section 7 of the Constitution imposes upon the state an obligation to respect and promote the rights guaranteed in the Bill of Rights. That the police are not trained cannot be an excuse. They can't breach or violate guaranteed rights because they were not trained. If the state is prepared to release police who are not trained into the streets, it should take responsibility for the violation of human rights those police commit. Isn't that the issue?
I accept that, Justice Jafta. I accept that.
Okay.
Mr. Bedesi, you've answered that. I just want to take you back to your submission that the failure to apply for bail is a new delict, and the applicant then bears the onus in that regard by failing to apply. Do you concede then that's a new law of general application, and that gives this court jurisdiction? That is a new point of law that the SCA has put forward.
I don't think that it is really a new point. We've never argued that it's a new point. It was always.
But you say it's
the law, circumstances.
Well, can you refer us, sorry, Mr. Bedesi, can you refer us to authority for that? if you say
I
it
don't
is
have
not
any
a
authority.
new point. Yes. So you will
What I
concede then
can
if there's,
say,
sorry, can I just put this to you? You concede then that if this is really a new point of general application, that this court then has jurisdiction to deal with. I'm referring back to right at the beginning when the question of jurisdiction
yes,
came up.
I think it was paragraph 41, which Justice Taron referred to us in the SCA judgment.
Yes.
Justice Victor, what the SCA said simply is, and we got to look at where the SCA is coming from. They say that if reliance is placed, and this is where they started off the judgment.
No, I understand that, but sorry, Mr. Bedesi, I understand that. But what I'm saying, do you now then concede that this is a point of law that this court should consider?
We submit that it is not a novel or new point, because it was merely an issue raised according to the SCA for type of dealing that is relied on, is all.
Thank you.
So there's no, and it's obviously based on the Constitution, which allows any person to apply for bail, or rather gives them the right to do so.
Mr.
Mr.
Bedesi,
Bedesi. Okay.
Mr. Bedesi, following your
Justice
yes, following your debate with my sister Teron on the Zealand principle, which the SCA did not apply, I just want to understand you correctly. Do you accept that the principle that says the respondent being the state bears the honors, as in this case, is the correct proposition or the correct principle of our law? And if
Yes,
it is so, the honors for the further detention was on the police to justify the detention.
Yes.
So the only problem or the argument that you're advancing is you are aligning yourself with the SCA judgment that seeks to stop the first process and say the second process introduces a delictual claim where the honors would change.
That was the argument.
Now, if you compare the two, do you still support what the SCA found about this secondary or this second element of the delict, or Zealand as in this court?
The SCA did not apply Zealand, Justice Matopo, for the simple reason that it was distinguishable. And each case, as the clerk said, must be determined on its own facts. If Zealand established a principle, then it will open the floodgates, because it simply says that once you're detained, you're arrested unlawfully or you're detained unlawfully, story's over. We don't have to even look at any other organ of state and what their rights and duties were. The police are liable. Surely we have to go further and see, did others also perform their obligations?
Is Zealand distinguishable, Mr. Bedesi? Here's why I ask you. The applicants, in so many words, as my sister Justice Chikwe drew your attention to, in paragraph 7.2, they refer to the arrest and the subsequent conduct of the second defendant and other police officers, as mentioned below. And then below in paragraph 7.3, they plead the assault and they say all of which caused the first plaintiff to make a statement incriminating himself and the second plaintiff. And then in paragraph 8, they say, as a result of the aforesaid unlawful arrest, detention, and assault, the first and second plaintiffs suffered damages. Just my sister Justice Theron read to you a passage from Zealand. And from that, we see that the focus is on, open quote, unlawful detention, close quote. That's what we must underline. That has little to do with how the unlawful arrest came about. It may be the result of an unlawful or a prior or antecedent prior unlawful arrest, or it may be, as here, the result of an unlawfully extracted confession, which once it's in the hands of the prosecutor leads to a detention and opposition of bail. There's the unlawfulness in both instances. How it arises does not matter much. Or are you suggesting that at that step, at that first stage, as Mr. Mahlangu and Mr. Mtsweni are on their way to court, they are not unlawfully detained? Surely you will say yes, and you have to say yes, or not?
I do.
Or not?
I can't hear, I'm sorry.
Oh gosh.
I think he has agreed
Justice
with
Matlanga, would you-
Matlanga.
Sorry?
I think he has agreed with the first
Yes,
part
I
of the
agree with
submission.
Oh, okay. All right. Let me continue. So if it is unlawful, and it is unlawful because of the unlawfully extracted confession, at what point does that change? Once you have that unlawfulness at that point, unlawfulness resulting in detention at that point, then Zealand kicks in and it says, the detainer must prove the lawfulness. Why
Justice Matlanga,
do you say Zealand does not apply?
because in Zealand, the detainer was not the police. It was correctional services. And yes, it's correct that they should be liable. In this case, the police's duty ended and did nothing further. After they arrested, they took the unlawful confession and they brought him to court. Once they come to court, there's nothing more that they can do in the absence of a bail application.
No, I'm sorry, Mr.
Magically happened. What else magically happened to that unlawful act of extracting the confession, which results in the prosecutor's opposition of bail? What magically happens to that we must suddenly forget about it? How can
They
that
are
be?
liable. They are liable for their justice, Matlanga. If it is shown, like it was shown in this case, that the prosecutor relied on that confession to keep them until the 14th of June.
Mr.
It is
Benesa,
after the 14th of June.
I just wanted
Justice
to
Jaffe?
correct you that in Zealand, it was not the correctional services that was held liable. It was Minister of Justice. It was the Minister of Justice, remember.
Minister of
Zealand
Justice and Constitution.
appealed, and his appeal against conviction and sentence was successful. But what happened was that the registrar of the High Court in Grahamstown did not send the warrant for release to the correctional services. And he continued thereafter appearing in the High Court, I mean, in the regional court. And his case, he was remanded in custody. And then when he sued the minister on the issue of lawfulness, the minister said, your continued detention was as a result of orders by a magistrate, and therefore it was lawful. So it has similarities to this case. The question was whether the orders granted by the magistrate in themselves or of themselves alone were sufficient to constitute a just cause. Okay? And the court said those orders, because were granted arbitrarily, the magistrate did not know that his appeal has been finalized and that he has succeeded when the postponements in custody orders were granted. So it is not that different from the present case. And again, in Woji, the SCA applied Zealand, which has facts which are similar to the present matter. The SCA applied Zealand, but the majority in the present matter did not apply Zealand. And that's the difficulty that we have. Why should Zealand not be followed in the present matter?
Justice Jafta, for fear of repeating myself, we say that Zealand need not have been applied because the facts there were different, and the issue for determination in Zealand was not the question of detention. The remand.
We lost you there, Mr. Petesi. Mr. Petesi?
He has frozen, his screen is frozen, Justice Kampepe. Mr. Mudlia, are you with us? Mr. Mudlia? We have lost the junior as well, Mr. Mudlia, Justice Kampepe. Justice Kampepe, may I suggest that we take a short adjournment at this stage?
We'll take a short adjournment of 15 minutes. Court adjourns.
Can I invite the registrar clerk?
Court will adjourn until 12:15. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with a video as soon when the hearing recommences at 12:15.
12:15, that's 5 minutes. Huh? Oh, sorry, I'm sorry.
Should you exit, you may use the same link to rejoin the hearing.
Justice Mahlangu, I would love 5 minutes because I want to finish.
Het was afgeleid.
Okay, now I'm back.
Mr. Badesi?
Justice Taron, I'm back on. I just changed my junior is savvy, so he did it. I apologize to the court. Please, it is
Mr.
not
Badesi,
because I had a hard time.
Mr. Badesi, the court has taken a 15-minute adjournment.
Okay, thank you, Justice Taron.
Thank
I apologize for that again.
No apology is necessary, Mr. Badesi.
Thank
You may switch your video off and you may mute yourself and rejoin on the same link, Mr. Badesi.
call him. Okay, okay, there. Okay, there. Okay, there. Put up your voice. Okay.
Oh.
You on the screen. Close it.
The registrar will call the matter.
Justices, all counsel are online. I call the matter of J.E. Mahlangu and another, and Minister of Police for hearing.
Mr. Petesi?
Justices, the appearance is as earlier. I apologize profusely for the loss in connection. I can assure the court it was not that because the going got tough that the internet faded. It was simply that I don't know what happened.
Yes, you may proceed to answer the question that was posed. Mr. Petesi?
It looks like he's frozen again.
And Justice Kampepe, Justice Victor is also joining us.
Yes,
Oh.
I must.
I wonder if Ms. Mudlia is with us.
He is not, Justice Chitli. But
It
may
seems to be in the same
I
place.
suggest we give Mr. Badesi a moment or two to rejoin? With your leave, Justice Kampepe, perhaps we can also ask the registrar clerk to telephonically contact Mr. Badesi.
Yes, please.
I will do so, Justice. Thank you.
Whilst contact is being made with Mr. Petesi, may I suggest that we adjourn for 3 minutes?
Yes, indeed. Thank you, Justice Kampepe.
As a call, please.
Am I back on the full video? No, I'm back. Justice Compare and a member of the court, I once again apologize. I don't know what happened there. Why are you there? I'm back on. Can I be heard? What's happening?
Yes, we can hear you, Mr. Badesi. Justice Kampepe, you were on mute.
Yes, we may proceed, Mr. Petesi.
Thank you, Justice Kampepe. Justice Jafta, I was busy with answering your question. The only viable reason I can give for the in answer to the question is that the facts in Zealand is distinguishable from the present, and that the application of that principle should not be applied in this matter.
All right, thank you, Mr. Badesi.
Thank you, Justice Jafta. Now everyone is on screen. I see that you on screen and me only.
Yes, thank you, Mr. Petesi. Do you have
Thank
any
you.
further submissions to make, Mr. Petesi?
I have no further submissions to make. That is as far as I can take the matter.
Yes.
And for the remainder that has not been dealt with today, it's in my heads of argument, and I'll abide by that.
Thank
If
you very much.
we are successful, we will obviously ask that it be dismissed with costs, including the cost of 2 counsel.
Excuse me, Mr. Bedesi, before you step off, can I ask something relating to the quantum?
Yes.
The applicants were held for a period of 9 months, and the SCA, the minority judgment, held that they should be compensated to the tune of 490, whereas the majority said 150, 120, but on a narrow point. Right. This court in de Klerk, where the detention was for a period of about 7 to 8 days, awarded the applicant stroke plaintiff an amount of 300,000. And it's 8 days.
Yes, Justice Matopo.
And you compare the 8 days
Yes.
with the 9 months, it's a huge difference. The plaintiff stroke applicant in this matter, when you look at their particulars of claim, they have claim amounts to the tune of 5 million. And if you exclude the claim that they were unable to prove the loss of income and capacity and incapacity, which was 170, then it would bring them much more closer to a figure of around somewhere in the region of 1 million plus. Now, I'm asking you this because I'm just worried about which you've alluded to, or your colleague, Mr. Rousseau, alluded to, which is a precedent. Remember, the judgment of this court will be read, and to avoid any uncertainty and confusion, I'm asking you as the minister who holds the purse, that if you compare de Klerk 300, 490 here, as well as the amount that has been claimed, what would constitute? I understand Mr. Rousseau aligned himself with the minority judgment by Justice van der Merwe. So I'm putting this question to you. and he's listening, and he will have an opportunity to respond to it. I did not want you to be disadvantaged when I put to him in reply.
Are we experiencing difficulties again?
Yes.
Yes, we are, Justice Kampepe. Mr. Badesi, if you can hear us, can you turn off your video, please? Mr. Mudlia?
Where's my
Mr. Mudlia, are you with us?
SCA?
Mr. Mudlia?
You know that notes I just see it in the box there somewhere quickly.
Mr. Badesi, we can hear you. Can you continue with your address, please, with your video?
Now it's connected.
Mr. Petesi? Mr. Petesi, please proceed without your video on.
Can I change computer? Let me change computer. Video. Can I be heard?
Yes, you may be. Yes, we can.
Justice Kampepe?
Yes, we can hear you, Mr. Petesi.
Thank you. I gather that what Justice Matopo wanted me to do was to applicants in this matter, that is the amounts which the one of the minority judges has awarded to them in the SCA. I had no objection to their claim for that amount which they abided by, and for that reason we did not address the matter in our heads of argument. However, during the break I managed to obtain my notes from my argument in the SCA, and from there it was apparent that the reason I am happy with those amounts, and I consider that amounts was based on the claims in Woji, where if my notes are correct, I talk subject to correction because it's an issue that was not dealt with by us. In Woji, an amount of 500,000 Rand was granted in 2014 for a period of 15 months of detention. And based on that, we then accepted that these amounts would be reasonable as claimed now for a period of 9 months. And we will have no objection to the amount which the applicants now seek. To go further than $1 million, it may be in accordance with the clerk, but then our courts have always shown an inclination to grant a greater amount for a shorter period of detention as opposed to a longer period. I did not address the issues as to why that has always been the trend in our courts. To work on a daily amount for longer periods would, I submit, result in excessive amounts in any circumstances. So I have no objection to the amounts they seek in these proceedings. I have nothing further to add on that.
Yes, Mr. Petesi.
Thank you, Justice Kampepe.
Any further questions from colleagues? In the circumstances, Mr. Pedesi, thank you very much for your argument. Mr. Rousseau will take your reply.
Thank you, Justice Kampepe. Thank you, other justices.
Justice Kampepe, I think we've already dealt with most of the issues that have been dealt in the argument of Mr. Pedesi. We persist with our submissions contained in our heads of argument. Regarding the issue of the quantum, our quantum was based on the judgment of Warji. And as I mentioned earlier on, when we appeared in the SCA, the judgment of the clerk had just been recently became available. So we did not take the judgment of the clerk in consideration when the order in respect of the quantum was argued. But on the other hand, if one looks at the judgment in the clerk, it appears as if the judgment in Boji is slightly disproportionate. But we will leave that in the hands of the Honourable Court.
That concludes your reply.
That concludes my argument, Justice Kampepe.
Any questions to put to Mr. Rousseau in reply? Thank you very much, Counsel, for your submissions. Judgment is reserved and the court adjourns.
As the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.
As the court pleases.